Before we successfully led the campaign to enact the ASFA Expanded Discretion Law, ASFA already had some wiggle room. There was already some discretion that foster care agencies could use to decide not to file termination of parental rights proceeding.
What this did is create an additional exception to the requirement that parental rights termination proceeding must be initiated any time a child has been in foster care for 15 out of the last 22 months. The existing federal exceptions were that the child is in the care of a relative, or that there's been a specific showing that it would not be in the child's best interests for the parental rights to be terminated.
The third exception is if there is a showing that the agency has not provided services to help the parent reunify.
What the Expanded Discretion Law did was add an additional exception that said that when parents are incarcerated or in residential drug treatment, or where they have previously been incarcerated or in residential drug treatment, and that is a substantial reason that the child has remained in foster care, then the agencies are relieved of the requirement of filing a termination of parental rights proceeding.
Often in the past, this was part of the motivation for the law, caseworkers would think, oh, parent incarcerated equals adoption or equals filing for a termination for parental rights, and that's absolutely not the case at all.
Now, a very important provision of the Expanded Discretion Law is this meaningful role requirement, because it requires the agencies to perform a thorough assessment of the parent's relationship with the children. Looking at all of the efforts that the parent has made, all of the ways in which the parent has maintained contact and tried to stay involved in the child's life, but also to talk to as many people as possible about the parent-child relationship, whether it be other relatives, attorneys, other participants in the court proceeding. One provision of the Expanded Discretion Law relates to the requirement that agencies provide diligent efforts to parents to help them reunify with their children. And one of the requirements of the Expanded Discretion Law is that the diligent efforts must include information to the parents about rehabilitative services, visiting plans, and other services that they can gain access to in order to reunify with their children, including services that might be available to them in the community after their release. Foster care agencies are required to provide incarcerated parents with a broad range of information about their rights and responsibilities so that they will be well informed of what their options are as well as what the legal requirements are. This is something that had not existed in prior law. An additional requirement of the Expanded Discretion Law is the Family Services Plan. This is a plan that's developed typically outside of the court proceedings in a separate administrative proceeding. Family services plans are now required to take into account the special circumstances of incarcerated parents, and also the incarcerated parents are required to be involved to the extent possible in developing the family services plan. It's important to stress that what the Expanded Discretion Law does not do. First of all, it does not say that an agency may not terminate rights of an incarcerated parent. It expands discretion, it doesn't limit it. In addition, it doesn't change the grounds for termination. So in New York, one of the main grounds for termination of parental rights is permanent neglect. That requires an inquiry into whether the agencies maintain diligent efforts, but also whether the parent has maintained contact and planned for the future of the children. And there's a very important New York case that said that long-term incarceration and long-term placement of a child in foster care is not an acceptable plan, and that rights could be terminated for somebody who's serving a long prison sentence. The Expanded Discretion Law didn't change any of that. It just says that the agencies are not required to move for termination, but they're still able to do so if those grounds exist. For family court judges, the Expanded Discretion Law does several things. First of all, it gives them greater discretion because they're not under the strict time limit imposed by ASFA. They can take more time with a case, really evaluate the parent-child relationship when a parent is in prison. The Expanded Discretion Law also gives the judges important new powers. They can order the agency to provide, to conduct a further assessment of the parent-child relationship. The agencies are required under the Expanded Discretion Law to assess whether the parent is able to maintain a meaningful role in the child's life. And the law requires or provides the judges with the power to order the agencies to do that and to go back and do it more thoroughly if the judges aren't satisfied that they have all the information that's available to them. Finally, what the Act does is it creates some new duties. The judges are required to take into consideration the special circumstances that incarcerated parents face that may inhibit their ability to visit with their children, to maintain contact with their children, or possibly even to keep the agency informed of their whereabouts. And the courts are required to take this into consideration in determining whether a parent's rights should be terminated. It's important for a parent's attorney, the attorney for a parent who's incarcerated, to be aware of the very difficult practical constraints that an incarcerated parent faces.
You know, if you only give them your office number and you're in court from 9 to 5, they're never going to be able to reach you, right? So you have to figure out some other way. If you're comfortable giving your cell phone, give your cell phone. If you're comfortable giving a Google number that would allow them to reach you after hours or on weekends or times that are just easier for you to be accessible to them.
The attorney for the parent may need to do some advocacy with the agency to try to find a way to facilitate the phone call so that the parent can satisfy her or his duty of maintaining contact both with the agency and with the child. But probably most importantly, the attorney for the incarcerated parent needs to realize that the incarcerated parent is going to be completely in the dark about a lot of things that are happening legally, and it's going to be more important possibly than even with a non-incarcerated client to keep that parent informed.
It's very important to write clients letters. I always send my business card again. I always let them know all my contact information once again, send them updated orders. And if there's any relationships that can be made with people at those facilities.
Every incarcerated parent is assigned a correctional counselor, currently called an offender rehabilitation coordinator, ORC, who is a potential communication source and someone who might be able to facilitate a phone call.
A counselor might not necessarily know that the person, that the detainee that they're working with has a family court case. So reaching out and also just saying who you are and what the case is about, that I think is helpful. One of the things that we did recently with the case is just, and the agency was open to it, is ask for for them to send the parent self-addressed envelopes for her to send letters to the kids.
An attorney for an incarcerated parent should be aware of a couple of other advocacy possibilities. One, of course, is making sure that the parent gets to court. This requires an order to produce. It's issued by the family court. It's sent to the prison, and that's what gets the parent into court. Now, that should happen more or less automatically once the court knows that the parent is incarcerated, but an attorney for the parent shouldn't assume that has happened. The attorney for the parent should first contact the court and make sure the order was issued, and then contact the prison and make sure that the order was received. One additional piece of advocacy that an attorney for an incarcerated parent can think about is making sure that the service plan reflects not only the parent's special circumstances, but also the work the parent has been doing inside prison. Many times, agencies and courts are unaware of the programs that are available in the prisons and the services they provide, and they really don't give credit to the parents for completing these programs.
A certificate might just say that, oh, this parent, this parent has completed transitional phase 2. Well, that doesn't mean anything to just someone looking at that certificate. So it's important to get behind that certificate, and that's what I try to do with my conversations with the counselors. Like, well, what do they learn in phase 2?
One other detail that an attorney for an incarcerated parent should consider is working with the attorney for the child and trying to find common ground and do some joint advocacy. Many times the child's interests and the parent's interests are aligned, at least in part. The work itself is for the agency caseworker is labor intensive. It's more difficult. It requires more resourcefulness to work with somebody who's in the prison system than somebody who is in the community. And so a parent's attorney needs to push, but also needs to be helpful, needs to provide the agency with the information it needs to know exactly what is possible, what's provided in the prison, what times a parent can make phone calls, under what circumstances, the basic details of prison life that an agency caseworker won't normally be aware of.
There's sometimes a myth that depending on where the parent is or the distance that means that the caseworker does not have to facilitate visits, and that's not true. Visits should always be facilitated at least bi-weekly, and then if that's not possible because of the distance, then on a monthly basis. In New York City, located within the child welfare system, is a program named CHIP.
CHIP is the Children of Incarcerated Parents program. CHIP facilitates visits between children in foster care and their parents that are incarcerated. CHIP transportation goes to correctional facilities in New York, New Jersey, Pennsylvania, and Connecticut.
But outside of that, there's bus services, van services, and foster care agencies, again, because of the legal requirement to provide these, have to reimburse foster parents for that transportation cost.
I frequently tell my clients is visiting is the most important service. Sustaining that relationship with your child, that they continue to know who you are, know that you're involved, know that you're asking questions about them. Visits and staying in touch with your child are going to be the most powerful indicator of why it would be harmful to that child, or not in that child's best interest to terminate that parental relationship.
It's important to stress that for an incarcerated parent, despite the many benefits of the new expanded discretion law, the most important advocacy will come from the parent, him or herself. It's very important for the parent to understand what his rights and responsibilities are, to be as actively involved as possible, to be as visible as possible, to reach out to caseworkers, to really take ownership of his case. There's no substitute for that kind of self-advocacy.
One thing I think can be really valuable for working with incarcerated parents when you first meet your client is to give them a journal or give them something that they can write on and say to your client, every effort that you make with your child, I want you to write it down. Every time you write them a letter, write down that you sent a letter. Every time that you reached out to the caseworker, jot that down. Every time you reached out to me, jot that down. Every time you left messages and nobody returned your calls, jot that down. Because when your client years later may have to testify about what the agency is saying they did, and they're saying that's not true, they can say in court, I kept a journal, and every week I sent a letter, and I wrote down every week that I sent a letter, and I have this journal. There are ways you can put that journal into evidence, potentially, or it lends a little bit of credibility to our clients' statements.
Probably the most important aspect of the expanded discretion law is the ability to keep a termination proceeding from being filed in the first place. And so a lot of the most important advocacy is going to be at the front end. First of all, the parent's attorney needs to make sure that the agency is conducting the assessment of the parent's ability to maintain a meaningful role in the child's life and to push the agency to do that. Related to that, the parent's attorney should become involved in that assessment. The parent's attorney should suggest sources of information that would be useful to the agency in making that determination, whether they be family members or others who are familiar with the parent and the child. And the parent's attorney should also be pushing the agency, telling the caseworker about the expanded discretion law, and reminding the caseworker that the expanded discretion law provides flexibility and that a termination case does not have to be filed. There are also some things that a parent's attorney can do if, despite all of these efforts, a termination proceeding is filed against the parent. And these would relate to showing that the agency didn't really provide the services necessary.
The caseworker can and should be cross-examined can be cross-examined on those. Are you familiar with expanded discretion? Did you send them their notice? Did you send them their rights and responsibilities? And then showing the judge that those things weren't done, and that can end up in a no reasonable efforts finding for the agency. It could end up in staving off a possible goal change.
Attorney for the parent can also ask the judge for further orders directing the agency to do more of an assessment, to get more information, and can argue that if the agency hasn't done that, that this should be a defense to any termination proceeding that is brought against the parent. If a termination proceeding is brought, notwithstanding the parent's attorney's efforts to keep that from happening, it will be important for the attorney at the termination proceeding to be able to argue that the agency has not met its requirements under the expanded discretion law. It will also be important for the parent's attorney to be able to argue that the parent has made every effort to maintain contact and get visits with her or his child. It will be important to make these arguments not just for the purpose of winning the termination proceeding, but for making a record, because even if the parent loses the termination proceeding, it may be possible to appeal that finding, and it will be important to have made a very clear record of the agency's failings and all of the efforts that the parent made.
I think one important component when you're appealing a termination is to ask for a continuation of visits pending the appeal, and I think you can generally only do that at the appellate division. You can argue that there would be irreparable harm to the parent-child relationship with 9 months of not seeing their child, especially if the appellate division may potentially reverse the decision.
With prisons, there's a clear set of requirements that apply throughout the state about visits and who may visit and under what circumstances. Residential drug treatment programs do not have the same set of uniform procedures. And so one of the challenges for a caseworker as well as a parent's attorney is to be well informed about what the residential drug treatment program will permit. Will it permit contact with outside people? Under what circumstances? Where will that contact be permitted? Is it possible for the parent to get out and go to court, and what's required to make that happen? Another difference between a residential drug treatment program and a prison is that typically with a prison, one can learn pretty precisely when the parent will be released from prison. With the residential drug treatment program, that's going to vary, and it's going to depend on what the parent's treatment needs are and how well the parent has been responding to treatment. And so it may be a little bit more difficult to make planning predictions.
Time and time again, you see numbers that show that children who age out of foster care are more likely to be homeless, they are more likely to be unemployed, they are more likely to end up in the juvenile justice system and then the criminal justice system. And so that there should always be this presumption that if there's any way for us to keep families together, that should be what we do. The state should only intervene and become the parent in extreme situations and in extreme cases. And I think with incarcerated parents, it's even more important to remember that fact.